Okay, can we start?
Yes.
Yes, sir. Thank you, sir. Assalamualaikum and very good morning. Saya dahului dengan Setiausaha Bahagian Hal Ehwal Sabah Sarawak, Encik Toshin Ganto yang bersama kita hari ini. Nama saya Norizan dari Hal Ehwal Sabah dan Sarawak. Selamat datang ke webinar kelima. Webinar ini ialah merupakan forum untuk membincangkan isu-isu semasa khasnya mengenai Sabah dan Sarawak. Kita dimaklumkan bagi semua diingatkan pada semua kita ialah bulan Ogos adalah merupakan bulan keramat bagi rakyat Malaysia, tidak kira di mana kita berada, sama-samalah kita dengan bangganya menghayati Hari Kebangsaan yang ke-64. This is slightly younger than I'm slightly younger than 64, sah. Sama-sama kita mengibarkan darah gemilang dan menghayati betapa murninya perjuangan pemimpin-pemimpin dan saudara kita yang dulu daripada kita. Ladies and gentlemen, perlembagaan satu negara itu begitu unik sekali dan tidak ada dua negara dalam dunia ini yang mempunyai perlembagaan yang sama. Pada hari ini kita amat bertuah sekali dan dapat berkongsi pengalaman dengan seorang pakar perlembagaan yang tak lain tak bukan yang berbahagia Profesor Emeritus Datuk Dr. Shad Saleem Faruqi atau lebih dikenali dengan Profesor Shad. Welcome, sir, to our webinar. We are certainly privileged to have you here. Tajuk kita hari ini ialah Special Position of Sabah and Sarawak under the Federal Constitution. Ya. Sedikit mengenai Prof. Shad, walaupun he did not need any introduction. Profesor Shad telah dedicated his life teaching laws for more than 40 years and still teaching, bro, at Universiti Malaya.
Yes.
He is currently the holder of the Tunku Abdul Rahman Chair at the Faculty of Law, Universiti Malaya. Beliau juga telah menghasilkan lebih daripada 600 penerbitan dan has done many national and international consultancy, including the drafting of the Constitution of Republic of Maldives in 1992. That is so interesting, Prof. Prof. Shad was also the fourth holder of the Tun Hussein On Chair in International Studies at the Institute of Strategic and International Studies, ISIS, Malaysia, for the period of July 2019 and June 2021. Saya dengan segala hormatnya mempersilakan Prof. Shad untuk berkongsi pengalaman dengan dan ilmu dengan kita semua. Dipersilakan, Prof.
Thank you so much. Thank you so much, Dr. Norizan, and Assalamualaikum warahmatullahi taala wabarakatuh. Yang berusaha Tuition Gantor, para hadirin yang dihormati. First of all, thank you so much for the privilege of this invitation. I wish to begin by stating that I'm going to present the constitutional law perspective. I'm a student and teacher of constitutional law, and that's my aim of promoting constitutional literacy. I do not try to be partisan on one side or the other, but I know that being totally objective or impartial is never entirely possible. So I hope to learn from you and from your questions. Please feel free later on to ask questions. Let me begin by saying that as we approach the 58th anniversary of Malaysia, we take note with concern a large reservoir of discontent and unhappiness in our sister states across the South China Sea. I know there are many other things that are also challenging, the COVID, the economy, but at the moment, let's concentrate on our West Malaysian relationship with East Malaysia. We need to put our heads and our hearts together to diffuse the tensions and find just and lasting solutions. Such tensions, I wish to say, are inherent in all federal systems. There are about 30 federal systems in the world, And I wish you to know that everywhere in the world, there are some problems between the federal government and the state government. In this country, the main problem was on the issue of tensions, that because the Alliance and Barisan National Government had such a massive steamroller majority, therefore, many of these areas of discord, disagreements went unnoticed. But since general election of 2008, when the Barisan National lost its 2/3 majority, 2013, 2018, politics has become more competitive, and democracy and free speech are finding greater expression. Consequently, we are witnessing the open airing of grievances. So there is a lot of alternative sources of information now, and there are a lot of people expressing their unhappiness. The internet, the social media is full of all sorts of views. Now, this is not entirely a bad thing. It shows an emerging democracy. Before internet came on, it's not that we were all very happy and content. No, our discontent was basically under the surface. Now this discontent is coming up and it's being felt. Now, may I point out that Sabah Sarawak are not like the other states of the Federation. They have an asymmetrical arrangement. In other words, Sabah Sarawak have special arrangement. Why should this be so? Because in federal systems, all states must be equal to each other. Well, that's theory. In reality, in all plural societies around the world, it is not uncommon to allow ethnic or other groups that claim a distinct identity to exercise autonomy over affairs of special concern to them. For example, Kashmir in India till August 2019, Quebec and Nunavut in Canada. In Quebec, if you have been there, they speak French, even though the language of Canada is actually English. Then regions in Switzerland, in Spain, Russia, Philippines, Thailand, Indonesia, they enjoy asymmetrical arrangements. So what I'm saying is this: giving to Sabah Sarawak special rights under our federal system is not uncommon. In many, many other federations and states, special regions have special rights. Now, when Sabah Sarawak and Singapore federated with Malaya to reconstitute the Federation of Malaya into the much larger and more diverse Federation of Malaysia, the significantly amended Perlembagaan Persekutuan granted them a number of ironclad guarantees of their autonomy and special position. Though the existing Perlembagaan of the Federation of Malaya was maintained, it had 181 articles. 89 of 181 articles, that is 49%, and 12 out of 13 schedules of the federal constitution were amended. So you can see quite clearly that in 1963, the federal constitution of Malaya, of the Federation of Malaya, was significantly amended to accommodate the reality of an enlarged and more diverse federation. 37 new articles were inserted into the federal constitution. 11 articles were deleted or removed. The nation was given a new name from Malaya to Malaya. However, the Yang di Pertuanagong stayed as the head of the state. And it was agreed that the heads of state of Sabah Sarawak will not be eligible to become the head of the Federation of Malaysia. So when it comes to the head of the Federation of Malaysia, that will revolve only between the 9 Malay sultans. Now, what was this justification for this special position of Sabah Sarawak? Can I just please check, Shazwani, are the slides available?
Yeah. Everything's going perfect.
Okay, good. Well, this special position was justified for many reasons. First of all, the 1963 Malaysia Agreement, MA 1963, between the Federation of Malaya, the United Kingdom, North Borneo, Sabah, Sarawak, Singapore was drawn up after a lengthy process of bargaining and negotiations. And one thing was very clear, that the delegates of Sabah Sarawak made it very clear to the IGC, Intergovernmental Committee, which was headed by a British fellow, but the deputy, number 2 was our Deputy Prime Minister Tun Razak. They were made very clear that the special treatment for Sabah Sarawak was a precondition for constituting Malaysia. So I think Sabah Sarawak delegates had made it very clear that they will not join unless they were given special treatment. Sabah summarized its demands in the famous 20 points, and Sarawak expressed them in similar 18 points. Now the IGC report, Intergovernmental Committee report of 63, and the Malaysia Agreement of 63, sadly did not incorporate into the Malaysia Act and into the Perlembagaan Persekutuan all the points of the IGC report and the Malaysia Agreement. I want to make this very clear, that though Sabah Sarawak's rights were agreed upon, special rights, the Malaysia Act 1963 passed by the Malaysian Parliament and the Federal Constitution of 1963 did not adopt all the features of the Malaysia Agreement and of the 20 points of Sabah and the 18 points of Sarawak. However, our courts in several cases have recognized the importance of these IGC report, the Malaysia Agreement, and has called them semi-constitutional documents. There are a number of cases. I won't take time to read them. However, I just want to point out, what's the status of these documents like IGC report, Malaysia Agreement, Cobalt Commission report? What's their legal status? Controversy remains about the legal status of these historical documents and these international treaties. Are they law and legally enforceable under Article 160, Clause 2 of the Federal Constitution? I'm sorry to report to you, especially those of you who are from Sabah Sarawak, I'm sorry to report to you that our Perlembagaan Persekutuan defines the word law to include written law, common law, and custom to the extent recognized. International law is not law by itself. International law needs to be given the kiss of life, incorporated. It must be adopted by an act of parliament. Pre-constitutional documents like the Cobalt Commission report, the IGC report, the Malaysia Agreement, they have tremendous moral force. They reflect a gentleman's agreement. But strictly speaking, they are not law under Article 160, Clause 2 of the Federal Constitution. Now, some of you may want to say more about this during Q&A. Now, around the world, historical pre-constitutional foundational documents are often employed to interpret the Perlembagaan and other domestic laws. I think that is so. It should be done. Nevertheless, do bear in mind that pre-constitutional documents, international treaties, are not law by themselves unless explicitly adopted into our body of law. Now, Sabah Sarawak's cultural and religious distinctiveness are there, and I think they justify special treatment. Also, Sabah Sarawak contribute huge territories. 60% of Malaysia's land area actually comes from Sabah Sarawak. Their combined area is 198,000 square kilometers, exceeding Peninsular Malaysia's 131,681 square kilometers. Their coastline is larger than the coastline of the whole of the peninsula. Sabah Sarawak are a major source of natural resources, petroleum, natural gas, timber. And sadly, despite that, poverty and underdevelopment in these states are widespread. I'm told piped water is not available in large areas of Sabah Sarawak. Roads, social and health facilities, and internet are certainly not on par with West Malaysia. And I think that's indefensible. That cannot be defended. Then many Sabah Sarawak people point out that the 1963 Malaysia Agreement is not merely a domestic agreement, but an international treaty giving international law basis to the guarantees for Sabah Sarawak. I agree with that. But as I pointed out, international law is not law by itself. Now, let's look at some of these guarantees. I'm looking at the law. Later on, I'll point out the practice on the ground, because between the law in the book and the law in action, there is always a wide gap everywhere in the world. Let's look at the law first. In lawmaking matters, legislative matters, Sabah and Sarawak have been given special autonomy. The Schedule 9 of the Bahagian has a supplementary state list for Sabah Sarawak. The lawmaking powers of the state assemblies, all the state assemblies, are allocated in list 2 of Schedule 9. However, there is a supplementary state list for Sabah Sarawak, which confers additional powers on these states in 6 matters, including native law and custom, incorporation, that is creation of state authorities, ports and harbors, land surveys, the Sabah Railway in Sabah, and water supplies and services. Then there is a supplementary concurrent list. Concurrent list is list of topics where both federal and state can make law. Sabah Sarawak have special topics. There are 9 matters in this concurrent list: personal law, adulteration of food, shipping under 15 tons, water production and supply, forestry research, charities, theaters, and in Sabah until 1970, medicine and health. Then under Article 76A and 95C, under these articles, the Yang di-Pertuan by order has conferred on Sabah Sarawak special powers to legislate on the federal matter of carriage of goods by land. So they have been given special power in this area by the Yang di-Pertuan under Article 76A and 95C. Then, though we are a federal state, and as we all know, land, forests are in the state list. States have the power. So Pahang has power over land and over forest. But actually, under the Constitution, Article 76, under the Constitution, Article 76, the federal government can acquire power to legislate on state matters for promoting uniformity of laws of 2 or more states. So this is what is called cooperative federalism. Even though the power is yours, in some areas, I can exercise your powers. In other areas, you can exercise my powers. Cooperative federalism. However, this power of the federal parliament to legislate on state topics for purposes of uniformity is not applicable to Sabah Sarawak. When it comes to Sabah Sarawak rights, federal government cannot take over. Land, agriculture, forestry, local government are exclusive to Sabah Sarawak. Those of you from West Malaysia will know, though land is the most important topic in the state list, the National Land Code is actually a federal law. The local government is in the state list. The Local Government Act is a federal law. Well, that is so only for West Malaysia. When it comes to Sabah Sarawak, the federal government cannot campur tangan. Land, agriculture, forestry, local government are exclusive to Sabah Sarawak. Okay, when it comes to amending the Perlembagaan Persekutuan, if that would affect the rights of Sabah Sarawak, then the procedure of getting 2/3 majority in the federal parliament is not enough. If the amendment affects the rights of Sabah Sarawak, then you've got to get the consent of the governors of Sabah Sarawak as well. I want to alert you, in the amendment of the Perlembagaan Persekutuan, the states, so Malacca, Negeri Sembilan, Kelantan, Pahang, Johor, they have no right to participate. They have no right. But Sabah Sarawak's consent must be obtained. So Sabah Sarawak has a special position. However, I want to alert you, those of you who are from Sabah Sarawak, especially Yang Barusa, Toisin Gantor, I think your lawyers in 1963, Yang Barusa, your lawyers made a mistake. They should have asked for the consent of the Sabah Sarawak Assembly. Instead, they negotiated for the consent of the governor. I think that was a mistake. So if the federal government wants to amend the Perlembagaan Persekutuan to amend the rights of Sabah Sarawak, what the federal government has to do is to pass the amendment by a 2/3 majority and get the consent of the governor of Sabah Sarawak. I think they should have Sabah Sarawak should have insisted on the consent of the Assembly of Sabah Sarawak. I know the governor is bound by advice of the Ketua Menteri, but nevertheless, I think this was a mistake by those who were negotiating. Now, sadly, some constitutional amendments have diluted the special position of Sabah Sarawak. An example is an amendment in 1976 to amend Article 1, Clause 2. Previous to 1976, the Perlembagaan used to say the states of the federation shall be A, and all the West Malaysian states were mentioned. B, Sabah and Sarawak. C, Singapore. So Sabah and Sarawak were mentioned separately because they were separate, they were different. In 1976, Article 1, Clause 2 was amended, and now all the names are put together in one list. In some respects, this was a status downgrade. Till 76, Sabah Sarawak were in a special category. Now they are just like one of the other 13 states. Then there has been some federalization of critical state matters such as water and tourism. Tourism brings in a lot of money. It was a state matter. By amending the constitution, it has now become a federal matter. Then Sabah Sarawak argue that the Territorial Sea Act 2012 has reduced the territorial waters from 12 to 3 nautical miles in violation of Article 2, Clause B. Let me explain. Territorial waters are regarded as part of the territory. So if you reduce the territorial waters, in a way, you are changing the territories of the state. So previously, territorial waters were 12 nautical. Now they are 3 nautical. And Sabah Sarawak rightly say, some people say, Sabah Sarawak rightly complain that you have reduced their territory. Under Article 2B, you cannot do that without the consent of Sabah Sarawak. Then another amendment was made. Previously, if a judicial commissioner was appointed to the High Court of Borneo, you had to get the consent of the Chief Justice. You had to get the consent of the governor after the recommendation by the Chief Justice of the High Court of Sabah Sarawak. Now actually it's the Chief Justice of Malaysia and the Yang di Pertuan. So the rights of Sabah Sarawak have been taken away here. Article 121, Clause 1 was amended to reduce the powers of the High Court, including the High Court of Borneo. Article 121, 1A was inserted to reduce the powers of the High Court of Borneo in the matter of Islamic law. Labuan was federalized in 1984. Now, next point, position of Islam. In 1963, there was no official state religion. I apologize. There's a typing error there. Let me correct that. I'll correct that later on. In 1963, there was no official state religion in Sabah Sarawak, but Sabah later amended its state constitution to insert a state religion. By the way, the 20 points of Sabah clearly said there shall be no state religion in Sabah. But this is a fault of the Sabah government itself. It amended its constitution to insert a state religion. However, in Sarawak, till today, there is no state religion in accordance with the 1963 agreement. However, in Sarawak, the Yang Dipertonegong is recognized as the head of Islam. But Sarawak does not have a state religion. In 1963, the federal constitution contained Article 161C, which provided that if financial support is given to Islamic institutions, then an equivalent amount will be allocated for social welfare in Sabah Sarawak. Article 161C was repealed in 1976. In 1963, there was an Article 161D, which provided that Article 11, Clause 4 will not apply to Sabah Sarawak. What is 11, Clause 4? 11, Clause 4 says that no one can preach to Muslims. 11, Clause 4 was not to apply to Sabah Sarawak, but this Article 161D was amended in 1976. So it appears that the native character of Sabah and Sarawak has been diluted over the years, and Islamization has been a key policy of the federal government since the 80s. In recent years, the move towards an Islamic state, the plan to introduce hudud laws, the attempt to export the peninsula's hardline Islamic trend borrowed primarily from Saudi Arabia, the restriction now lifted on import of Bibles in Malay, and the federal court decision in Roman Catholic Archbishop of KL, they caused discomfort in Sabah Sarawak. In this titular Roman Catholic Archbishop, the issue was whether the Bible in BM can use the word Allah and some other Malay Muslim words. Now, as you all know, Sabah Sarawak do have Sharia laws. These Sharia laws have enacted that in case of native Muslims, Sabah Sarawakans who are Muslims, native law will not apply. The Sharia law will apply. That's what the Sharia law says. This has led, I know this has led to some conflicts when the natives who are Muslims want to go to the native court. They do not want to go to the Sharia court. So there is some discomfort and some disputes there. In Sabah Sarawak, native law is widely used, and that should be so. However, many natives have complained that the status of native courts is lower than the status of Sharia courts in West Malaysia. So they feel that the status of native courts should be enhanced at least on par with the status of the Sharia courts. I've already covered this point of judicial commissioners. Empanelment. The Intergovernmental Committee report, I'm on slide 26, recommended that when an appeal involves the rights of Sabah Sarawak, the federal court sitting to hear the appeal must have at least one judge from Sabah Sarawak with Borneo judicial experience. This recommendation of the IGC has not always been honored. Quite often you have the rights of Sabah Sarawak being litigated, but all the judges are West Malaysian judges. There is no judge with Sabah Sarawak experience. Now, I was pointing this out to you. IGC report, sadly, is not law, properly speaking. It is more of a gentleman's agreement, a moral agreement, an international agreement, but it's not strictly speaking law. Native law cases involving land, livelihood, and custom are very controversial. It's a huge area, and I won't be going into that. These cases are often heard by peninsular judges with no Borneo experience and no appreciation of the way of life of the natives. However, I must say that there are some sympathetic decisions. However, a lot of the natives of Sabah Sarawak complain that they lose their cases in the courts because the peninsular judges don't have an understanding of the native way of life in Sabah Sarawak. Representation in Parliament, Sabah has 25 MPs, Sarawak has 31 MPs. Together, they constitute 25.2% of the MPs. So 56 out of 222 is 25.2%. However, from the political point of view, this is not enough to block a constitutional amendment. Constitutional amendment can be blocked if you had 33% of the seats. In 1963, Sabah Sarawak, Singapore had 33% of the seats. But with Singapore's exclusion, Sabah Sarawak's representation went down to 25.2, which means you cannot block a constitutional amendment. Emergency powers, even during an emergency, under Article 150, the native law or custom of Sabah Sarawak cannot be affected by emergency law. However, I have to report with sadness that in 1966, the federal government used or abused its emergency powers to remove the then Chief Minister, Stephen Kalong Ningkan, from power to declare an emergency in Sarawak. Development plans. This is good, very good. I'm sure you'll be happy to hear. Policies of the National Land Council and the National Council for Local Government are not binding on Sabah Sarawak. Fiscal, financial federalism. The federal government's stranglehold over most of the lucrative sources of revenue is not as strong in relation to Sabah Sarawak as it is in relation to other states. In any federalism, there should be fiscal federalism. Money, income should be divided in such a way that the states have enough money to perform their functions. In Malaysia, there is no fiscal federalism. However, Sabah Sarawak have some fiscal privileges that are not available to the peninsular states. What are these? There are some special sources of revenue. Sabah and Sarawak are entitled to earnings, to taxes, fees, dues on 8 sources of revenue, like import and excise duty on petroleum products, export duty on timber and other forest produce, royalty on minerals, 30% customs revenue on medicine and health products, state sales tax, state ports and harbors, state water supplies, revenue from licenses connected with water supply. So there are some special sources of revenue. State sales tax is in Sabah Sarawak hands, and there is a big dispute between Sarawak and Petronas on the issue of state sales tax on petrol. This dispute has been resolved secretly, confidentially, so we don't really know what the terms of the resolution were, but there was a court case pending. Sabah and Sarawak enjoy some special grants guaranteed by the Perdana. They're entitled to import duty and excise duty on petroleum products. There are some mandatory allocations for Sabah Sarawak. Oil royalty, however, is a problem. Sabah Sarawak get only 5% oil royalty, and they feel that it should be more than that. The figure they are asking for is 20%. Article 153, special position of Malays and natives of Sabah Sarawak. This is there in the Bahagian, but Sabah Sarawak can say that the protection of 153 is not vigorously enforced, in contrast with strong affirmative action of Peninsular Malays throughout the nation. Borneoization of the public services is proceeding too slowly. There are still lots of jobs in Sabah Sarawak being held by West Malaysians. Immigration. Sabah Sarawak have special rights on immigration, but because of illegal immigrants, the population of Sabah has increased 125% in the last few decades. So rights of Sabah Sarawak to control immigration has been defeated by the federal government's naturalization of millions of illegal immigrants into Sabah. Lawyers, West Malaysian lawyers have no right to practice in Sabah Sarawak except by special permission. And even if the Sabah Sarawak case comes on appeal to the federal court, West Malaysian lawyers don't have a right except with special permission. English and native languages have a special status. National Language Act does not apply in Sabah Sarawak without the permission of Sabah Sarawak. Malay reserves don't apply in Sabah Sarawak. In Sabah, there are 6 appointed members in the Sabah Assembly. However, federal control over politics is there. Despite the autonomy in the above areas, the federal government has in the past tried to control political and administrative processes in Sabah Sarawak. Federal government manipulated the political process to remove Kalong Ningkan in 1966 and Joseph Pairin in Sabah in 1994. In fact, federal government went to the extent of declaring emergency in 1966 in Sarawak. There is a dispute. Every year there is this problem coming up. It will be coming up in the next few days. East Malaysians note with displeasure that Malaysia Day was not celebrated as a holiday till 2010. And so there is always this yearly controversy about how old is Malaysia. Is Malaysia 64 years old or is it 50 years old, 58 years old? I'll let you give your answer during question time. Much depends on whether you begin from 1957, you begin from 1963. Secession in Sabah, in Sarawak, there is some movement that says we should secede, leave the federation. Actually, there is no right to secession. Even the 20-point agreement with Sabah clearly states that there is no right to secession. Secession means the right to leave and become an independent country. There was some attempt a few years ago to create this single category of Pribumi to extinguish the existing categories of the various ethnic communities and to unite them under one nationality, that is Pribumi. Conclusion, 50 years down the road, not all is well with former Borneo state's relationship with the center, with the federal government. As has been pointed out above, in many areas, Sabah Sarawak's autonomy has suffered retreat due to constitutional amendments, political, social, and religious developments. So we need to do something to douse the embers of controversy. The federal government must recognize that Sabah and Sarawak's restiveness is real and must be addressed. A thorough study of constitutional, legal, financial, political instruments needs to be undertaken. The MA 63 Committee 2018 when after the election, when Barisan Nasional lost, Pakatan Harapan did appoint an MA 63 committee. Then another one was appointed in 2020. It has made some progress, but not much. Perhaps a royal commission is necessary. Balancing the concerns of equity and efficiency in intergovernmental financial relations is very important. I have to confess that petrol royalty issues have triggered separatist movements in many federations. Please don't forget North Sudan, South Sudan, Biafra, Nigeria, in Iraq, sharing of petrol revenue is a big problem amongst the various regions. So petrol royalty issues have triggered separatist movements in many federations. So we need to sit down on the drawing board again one more time and ensure an amicable settlement. The settlement should be such that investors are not scared off. At the same time, it is fair to the states as well as to the federal government and to Petronas. There's a need to strengthen institutional mechanisms for regular non-partisan dialogue between the federal government and Sabah and Sarawak, so that the inevitable tensions that are inherent in a federal setup can be resolved with the least friction. We need to recapture the spirit of accommodation, moderation, and compassion that animated the leaders of the Malaysia Agreement in 1963. The federal government and West Malaysians must rededicate themselves to the agreements of the past. We need greater constitutional literacy to appreciate the scheme of things in 1963. What you have done today, organizing this seminar, is actually a small effort in that area. We need constitutional literacy to understand what the Perlembagaan says. People of the peninsula, and that includes me, should open our eyes to the commendable example of inter-ethnic and inter-religious harmony in the Borneo states. Borneo states do much better than West Malaysia. Sabah and Sarawak, on their part, must recognize that growth and evolution are natural and necessary in any federal setup. Federalism is a journey and not just a set of institutions and procedures. So I think we all need to sit down together. Right. So we all need to sit down together and look at the documents of the past, the agreements of the past, and see what needs to be done to honor them, and also what needs to be done to renegotiate them, to take note of the realities of the times. Thank you very much. Assalamu alaikum. That's all, Norizan. Thank you.
Thank you very much, Prof. I'm sure some people have burning question to ask you. Saya mengucapkan terima kasih kerana Prof sudi berkongsi ilmu dan pendapat dengan kita. Prof telah menggariskan kepada kita bahawa mengapa Sabah dan Sarawak diberikan kedudukan istimewa di bawah perlembagaan Malaysia. Dan Prof berkata di situ je, federalism is still a journey. Dan
yes,
dalam conclusion, Prof, I love this word. We need to recapture the spirit of accommodation, moderation, and compassion that animated the leaders of the Malaysian Agreement in 1963. The federal government and West Malaysian must rededicate themselves to pact of the past. Begitulah harapan kita, Prof. Prof tadi ada bercakap sikit pasal bahagian hal ehwal Sabah dan Sarawak. Saya nak bagi sikit penerangan. Bahagian Sarawak ini sebenarnya ialah mengambil tugas dan fungsi penyelarasan serta urus kesetiaan yang dilaksanakan sebelum ini oleh pasukan petugas khas MA63 dan ditempatkan secara pentadbiran di bahagian hal ehwal undang-undang masa itu BHESS JPM ya. Bahagian Sabah Sarawak ini berperanan memantau dan menyelaras isu-isu berkenaan Perjanjian Malaysia 1963 ataupun lebih dikenali oleh ramai dengan MA63. Saya ingin membuka kepada pendengar kita sekalian untuk menanyakan soalan kepada Profesor Shad. Saya akan baca pada Prof. You okay, Prof? Apakah soalan?
Yes,
Sure.
yes.
Yeah.
I have a question.
Okay. This is question from Harold Tan. Is English still an official language after so many amendments of the Federal Constitution over the years? How many of the amendments were done on the Federal Constitution without the consensus of the Bornean states? Prof?
Yeah, actually, I did give, you give me a minute, I will get the slides open. I gave quite a few examples of amendments done without the consent of Sabah Sarawak. Let's have a look. The Amendment Act of 1976, amending Article 1, Clause 2, whereby Sabah Sarawak are no more a special category and they are lumped together with the others. Then Act amendment to take tourism and water away, Territorial Sea Act, appointment of judicial commissioners, Article 121, the powers of the High Court in the area of Islamic law was reduced. Many of us support that. Sharia court should be independent, but the legal question was the consent of the governor of Sabah Sarawak obtained before you reduce the powers of the Sabah Sarawak High Court? Article 121A was amended. Labuan was federalized. In the case of Labuan, the state government itself actually is the guilty party. You pass the amendment to your Sabah constitution. So these are some of the amendments already done. In the case of Bahasa Melayu, Article 152, Bahasa Melayu is the Bahasa Kebangsaan. I don't think any amendment to the Sabah Sarawak Constitution was made. In 1963, it was given, Sabah Sarawak were given autonomy.
Hello, good morning.
In the matter of language, Sabah gave up this autonomy, but Sarawak still has not given consent to the National Language Act. So in Sarawak, English is still the official language. So these are some of the amendments, Dr. Nurisan, that were made without the involvement of Sabah Sarawak. But as I pointed out earlier, Dr. Nurisan, and maybe this is something that you and your bosses must sit down together and discuss. You should not only look at Malaysia Agreement, you should also look at the Malaysia Act, because it's the Act that became law. And you should look at the Malaysia Constitution in 1963. Malaysia Agreement, as I said, is a pre-constitutional, extra-constitutional gentleman's agreement. And the million ringgit question always is, are these pre-constitutional agreements law or not? Like in England, the Magna Carta, the Bill of Rights, are they law or are they simply moral documents?
I have a question from Encik Asmat Raidin. Where are you, sir? You want to ask question?
Yeah. Good morning.
Good morning. It's quite noisy. I don't know what's the background. Sorry.
I am local Sabahan.
Okay.
I keen interest to listen the presentation of our prof. But my interesting question is, just now I heard Mr. Prof said that the Sabah Sarawak has not right to succeed from the federation, according to the 20-point memorandum. But my question is it the memorandum 20 point legally binding or not? And then in Malaysia agreement 1963, there is no single word mentioning that Sabah and Sarawak has no right to succeed from the federation. Thank you.
You're right entirely. First of all, Kopi Wasian. I want to greet you in the Sabah way. You're right that the 20 points are not law, and therefore you're right. In the Malaysia Act, in the Constitution, there is no mention of, there is no prohibition on seceding, but the other
Even
laws
in
of
the-
Malaysia apply. The Sedition Act will apply. The Penal Code will apply. And any attempt at secession would actually be a penal offense. Regions of any country, not just Malaysia, any country, whether India or whether, let us say, the United States, they have no right to secede. No one has a right to secede. In international law, my understanding is this: there is a right to self-determination,
Yes.
provided you are a colony or a mandated state or a trustee state, then there is a right to self-determination. But once you are part of a federation, there is no right to secession. This is distinct from confederation. If you are part of ASEAN or part of EU, then Brexit is possible. But if you are part of a federation as opposed to a confederation, there is no right. So I'll answer it in one line. No, no one has a right to secede. No one. If
In
it
the
is right to secede, that will be a criminal offense.
no, in the federal constitution also not mentioning about it, right?
Yeah, it doesn't matter. Federal constitution doesn't talk about no one can walk naked. It doesn't mean that you can walk naked because the Bahagian doesn't say so. You have to look at other laws. There is no right to secede. That's my answer. Let's move on to something else. If you have other views, fine. There is
Dr.
no right to
Narizan,
secede.
good morning. Hello, Dr. Narizan. Dr. Narizan, good morning.
Good morning, sir. I can hear you clearly.
This is Datuk Ronald here. I'm from Labuan, actually.
Yes, Datuk Ronald. Apa
I would
khabar
like to
orang
ask
Labuan?
some
Yes.
questions, Is
Yes.
regarding about the constitution that has been amended by the state government since 1976. Can it be amended again by using the state legislative assembly, Sabah, to amend all the mistakes done by the previous government in 1976? Can it be done?
Dr. Ronald, that's an excellent question. And I will give an answer. It may disappoint you a little bit. When it comes to amending the laws of Sabah, then of course the state assembly is in charge. But when it comes to amending the Perlembagaan Persekutuan, then Article 159 and Article 161 capital E are involved. And I'm afraid that Sabah Sarawak cannot by themselves amend the federal constitution to undo, to erase all the errors. What you can do, however, is, and now is the time, because of the politics of the country, Sabah Sarawak's importance has grown tremendously. You've got 56 supporters together, 56 MPs in the Dewan Rakyat.
But can
Sabah
it be
Sarawak
done
together.
by the Sabah State Assembly itself by doing so to amend all these wrongdoings done by the previous state government?
No, you cannot. Constitution of Malaysia must be amended by the federal parliament. The Constitution of Malaysia cannot be amended by the Sabah Assembly.
Well,
What you can do is to apply political pressure to ask them to re-amend the amendment with your consent.
okay, meaning to say, since there are a lot of federal, I mean the West Malaysian political parties that is in Sabah and Sarawak at the moment. Do you mean to say that all the MPs must be from the local party itself? That can give us the extra power to amend the federal constitutions. Do you mean like that?
Now, I didn't mean any of that. I'm just saying simple thing. If you want to amend the Perlembagaan Persekutuan, it has to be done in the federal parliament. It cannot be done in the state assembly. I'm just saying that with 56 MPs in the Dewan Rakyat, Sabah Sarawak have some political influence. And
Well, I
you
think
should
so far the state assembly has never raised any issue pertaining to state legislative amendments so far. I think this is the right time for the state government to change.
Yes.
And to amend all the wrongdoings done by the previous state government since 1976, especially oil, gas, and all the natural resources that has been taken away from us.
Yeah, Datuk, you hit the nail on the head. Datuk,
Exactly.
You correctly pointed out many of these changes were made with the consent or connivance of the state governments.
Well, I have to praise the state government to do so, to act on these issues.
Yes. You
They
must
cannot just sit there and just
Betul.
Tidak boleh.
But nevertheless, the procedure has to be such that the constitutional amendment bill, let us say 2022, must initiate in the federal parliament. Though it will be because of
the requirements. The state government and the people of Sabah and Sarawak must act from now.
Yes. Okay.
This is the time that they have to awake themselves to ensure that the future generations will enjoy the natural resources of Sabah and Sarawak. That's it, Prof. And Dr. Narizan, thank you very much.
Thank you, Prof, for sharing with us the answer to the question. I think some of the questions are posted to you. Some you have already answered. Ms. Jovilis here asks, is it possible we make a new agreement to replace MA 63? You have explained, sir. From Asma again, is memo 20 point is legally binding? I also believe you have explained that. I have here from Nicholas Bowin. Where are you, sir? He wants to ask question.
Doctor, you hear me or not?
Yes,
yes,
I can
Nicholas,
see.
yes, sir.
Yes.
Thank you, Professor, for such a very good presentation. I have a few concerns to raise here and question perhaps. Number one, when Singapore was kicked out or left Malaysia in 1965, is Malaysia still valid as a nation? Because the agreement was signed between four equal partners, Federation Malaya, Singapore, Sabah, and Sarawak. But once Singapore was kicked out, is the agreement valid, or is Malaysia as a nation is still valid? That's one. Number two, you have raised a very good point on the appointment of federal judges. Apparently, the land cases in Sarawak is so many.
Yes, sir.
And as far as the cases have gone to the federal court, none from Sabah and Sarawak are appointed as the members of the judges at that level. So is it, to me, this is not very fair. The reason is I experience having myself to be as a witness in the case. My knowledge about the adat is I must say that we practice the unwritten laws, customary laws. You know, our adat have existed much earlier than the written laws, but none of the judges appointed to the federal court have much knowledge as much we do. A lot of the practice are not written. So as a result of that, we become the victim. A lot of the decision after the case of Tuan Rumah Sandah, we lost all the cases after that because our practice was not written that much. Okay, third point is the word Bumi Putra. Is it stipulated in any law in Malaysia? And lastly, review of the MH63. Is there such a thing that this Malaysian agreement can be reviewed? That's my question, Professor.
Thank you so much, Dato. Fantastic questions. The first one is very difficult, so I'll come to it last of all. Let me go with the simpler ones. Can MA63 be reviewed? Of course, it can be reviewed with the consent of both parties. Dato, the law of any country can never capture all the challenges of life. Life is always larger than the law, and that is why every constitution provides for its amendment. So I think the spirit of MA63 in some areas is not working so well. We need to sit down together at the table of friendship and fellowship and rework some of the arrangements. I have no doubt that the Perlembagaan Persekutuan can be re-amended in a spirit of accommodation and should be re-amended, should be amended. And in some cases, there is no need to amend the constitution, but maybe ordinary laws could be made to accommodate the aspirations of Sabah Sarawak. So there is no problem about reviewing, provided it is done in a democratic way rather than imposed. Then as to the issue of Bumi Putra, you are entirely right, Dato. In the Perlembagaan or in any law passed by Parliament, as far as I know, the word Bumi Putra occurs nowhere. The Perlembagaan uses the word Malay. Article 160, clause 2 defines Malay. Article 161, 162, they define native of Sarawak. And I think about 28 groups are mentioned. Then the native law ordinance in Sabah defines the meaning of the word native. The word Bumi Putra is a political coinage. There is no category of Bumi Putra in the federal constitution. The constitution talks of Malays and the natives of Sabah Sarawak. Sarawak natives are defined in the Perlembagaan Persekutuan, but Sabah natives are not defined in the constitution of Malaysia, but in Sabah law itself. All in all, I think the categories are about 28 or so in Sarawak, 32 or 34 in Sabah. All in all, we have actually about 60 plus categories of natives. And the word Bumi Putra is a political coinage. I totally agree with you, Dato, that Sabah Sarawak have a rich, diverse history of native customs. And I think no court should hear a case from Sabah Sarawak, especially involving native law, unless one or two judges who are empaneled have Borneo experience. They need not necessarily be from Sabah Sarawak, but they must be experts in Sabah Sarawak native law. It's possible that someone may be an expert in Sabah Sarawak law without necessarily being a native, but he must have lived there and learned from the rich culture of Sabah Sarawak. There have been challenges, Dato, in the courts when a case sat, when a court sat without a Sabah Sarawak judge on it. Some people challenged and said this is a violation of IGC, and sadly the federal court held IGC is not law. Intergovernmental Committee report is not law. It is merely a practice. But I disagree with this decision. I think the spirit of IGC should be respected. I would also give the principles of natural justice as a ground for arguing that if there is a case involving Sabah Sarawakians, then some of the judges must be from Sabah Sarawak to be able to give a more mature and richer perspective. I mean, if I may just give a case, if a family law court is hearing disputes between husband and wife, and all the judges are male, I think that's not fair. That's not fair at all. I think some judges should be female and some judges should be male, so that both male and female view can come out. I would say the rights of the Sabah Sarawak judges to hear a case from Sabah Sarawak is not only part of the IGC. I would elevate that to the status of even the principles of natural justice. And Datuk, principles of natural justice are part of common law. And common law is part of law under Article 160, Clause 2. So I would give the right, I would impose a duty on the Chief Justice that you must, under the common law, accept this fact that the paneling should be done in such a way that at least there is one judge from Sabah Sarawak. Now I come to your most difficult question. Is the Malaysia agreement still valid? Because one of the parties, Singapore, has left or was asked to leave. Not only Singapore, even the British government that was the colonial master at that time is of course no more. So actually two parties have left. Now my understanding of the situation is this, that a contract does not fall simply because one of the parties by mutual agreement withdraws. So I think the MA 63 is very much part of our legal constitutional jurisprudence, even though Singapore and the UK are no more in consideration. I think it is still law.
Thank you, Prof. There's a question, Prof, but I think you have explained earlier that Ms. Betty Chan asked you if Sabah and Sarawak are considered the state of Malaysia now, when the West Malaysian enter Sabah and Sarawak, still required to have endorsement from the immigration. I think you have answered this, but maybe you would like to clarify, Prof.
Yeah, no doubt about it. That I mean, we are all citizens of the same country, but one of the firm agreements which incorporated into the Immigration Act is that Sabah Sarawak will have control over immigration. So there is nothing illegal about me, West Malaysian, going to Sabah Sarawak and being required to obtain a permit, or me wanting to work there being required to obtain a work permit. I know this is unusual. That's the point I made, Dr. Norizan, about asymmetrical arrangements. I know normally there should be freedom of movement, Article 9 of the Perlembagaan Persekutuan. But Article 9, freedom of movement, has to be subjected to the amendments made to the Perlembagaan in 1963, that Sabah Sarawak have definite right to immigration, so that the jobs and the positions are not all taken over by West Malaysians.
Thank you very much, Prof. Any other burning question, or shall I read some of the questions posed to the good professor? This is a rather a long question, Prof. From one Muhammad Hasif Wan Hasan. Soalan saya, dia berkata begitu, adalah penting semangat federalism diangkat dalam memelihara perjanjian MA63 yang telah disepakati. Namun apa yang dilihat sekarang, pembentukan Malaysia sendiri itu tidak diperhalusi sepenuhnya. dan antara soalan mengenai status Sabah dan Sarawak sebagai equal partner bersama Malaya, penubuhan Malaysia sebagai sebuah persekutuan yang baru atau kesinambungan daripada tanah Melayu yang diperluaskan dengan kemasukan wilayah baru. Ini juga boleh dilihat dalam argument oleh pihak PBB berhubung keahlian penyertaan Malaysia di peringkat pertubuhan tersebut yang berpandangan Malaysia adalah merupakan pengembangan wilayah, bukan pembentukan negara. Apa pendapat Prof atas soalan ini?
Yeah, it's a very
long question. Yeah.
It's a very controversial issue, and I'll just give you my opinion. Please feel free to disagree. This whole idea of Sabah Sarawak being equal partners with Malaya has always puzzled me. I don't think Sabah Sarawak are equal to the whole of West Malaysia. That doesn't make sense to me. Sabah has only 2 senators. Sarawak has only 2 senators. Perlis also has 2 senators. So you are not amongst the appointed senators. There are, of course, 44. Amongst the indirectly elected senators, there are 13 times 2, 26. Sabah Sarawak has only 4. Sabah Sarawak doesn't have 24. Sorry, no, 22. West Malaysian states have 22 senators, so Sabah should also have 22 senators, Sabah Sarawak, but that's not so. This idea, you're not equal partners with Malaya. It was never so. You are a state of the federation, but a very special status. So I have difficulty about this entire argument, equal partners with Malaya. In what way are you equal partners with Malaya? In your relationship, in your representation in Dewan Rakyat or in the Dewan Negara? I mean, if you are equal partners with the whole of Malaya, then out of 222 MPs, 111 should be from Sabah Sarawak and 111 should be from Peninsular Malaysia, but that's not so. You have only 56. By the way, in the Constitution of Malaysia, in the Malaysia Agreement, in the Malaysia Act, Sabah Sarawak were always described as states. I know that in the 20 points, Sabah wanted to be claimed to be a nation. They use the word nation, not a state. But as I said earlier, the 20 points actually are a pre-constitutional document. So in my view, Sabah Sarawak were always states, but very special states. They were not a separate nation. They are not certainly equal partners with the West Malaysia. No way is there evidence of that, except maybe politically. So as I mentioned to you earlier, I'm not interested in the political part. So if you want to secede, that's up to you. I can just only give you the legal position. Under the Constitution of Malaysia, you are not an equal partner with the Federation of Malaya states. However, you are not just like Pahang or Johor or Negri Sembilan. You are very special. And I did spend some time mentioning those special provisions for you. Thank you.
Thank you, Prof. Sabah Sarawak is indeed very special. We have a question here from Mariati Robert. Dia berkata, Prof. Shad, what is the impact of the Sabah Special Grant First Review Order 1970 Part 4 Section 2(1)?
Mariati, you have to give me time to look that up in the Maaf. I don't have that with me. It's a very specific order. I'm sorry, I don't have it with me. I'm not very good with money matters. I apologize. I need time on this. Maybe what Mariati could do is, if you don't mind, if you could frame your question and write an email to me. I will search for this order and I'll be happy to give you a post-seminar view on this. That's all that I can promise, but I must confess that I'm quite ignorant about this order. I apologize. There are thousands of laws.
Okay, I'll do that. Yes.
Mariati, okay? You are okay? Yes.
Maybe you could summarize
I'm
it.
okay with that. Thank you. I'll do that.
Oh, there is. Yes. Thank you, Prof, for sharing with us. Is there any question from the audience?
Doctor, can I ask one more question, Doctor?
Yes, sir.
Yeah, Professor, after Singapore was, Singapore left Malaysia or being kicked out from Malaysia. Currently, Sabah and Sarawak and Singapore at that time they have 33%
Yes.
members of parliament. Consists of 33% of members of parliament. And after Singapore left, so Sabah and Sarawak has now about 25%.
Yes,
Now,
sir.
how do we rectify the number of member of parliament that is brought by Singapore, and now that Sabah and Sarawak has only 25%? What is the mechanism, or how do we rectify what number that have been taken or being minus Singapore? How do we rectify that situation?
That is ultimately, legally, there's no problem at all. Ultimately, it will be a political issue, actually. All that needs to be done is to amend the Perlembagaan Persekutuan at the federal level. And in the Perlembagaan Persekutuan, the representation of each state in the Dewan Rakyat is mentioned. So what needs to be done is actually that the representation of Sabah Sarawak should be enhanced, should be increased, so that all in all, Sabah and Sarawak return to their 33% that was there in 1963 before Singapore was asked and allowed to leave. So it should be no problem at all, but it's a political decision. Of course, the pre-amendment procedures are there in the sense that the Election Commission has to redo the boundaries to create more constituencies in Sabah Sarawak. But I see no legal problem whatsoever. Every 10 years or so, the electoral lines and numbers change. We began, I think, with 96 MPs. Today now it's 222. And I'm sure the number can be increased. So that either we increase the representation of Sabah Sarawak, or the other way could be to decrease the representation of the Malay states. But I know that will not sound so good. But the point is this: Sabah Sarawak have special rights, and therefore these rights need special protection. And I think increase in the representation of Sabah Sarawak in the Dewan Rakyat is justified by amending article of the Constitution relevant to this point. Thank you.
Thank you, Professor. Thank you.
From Lisa, she said to you that Salam Prof, since independence was extended from an already independent state of Malaya to the Borneo state, and by the virtue of the special status of Sabah and Sarawak, shouldn't the Borneo state not call negeri? If so, what should Sabah and Sarawak be called if not negeri Sabah stroke Sarawak?
Yeah, I think that point was taken up earlier. I know in the 20 points, Sabah wanted to be called Negara, and at one time for about, I think 10 years, it was Yang di Pertua Negara, not Yang di Pertua Negeri. But then this was amended. Now all the states are Negeri. So that's the way it is today. All the states are Negeri. Now if you want to change that, Sabah and Sarawak want to call their Ketua Menteri a Perdana Menteri. This is not unusual. I just want to inform Dr. Norizan, in India, Kashmir was like Sabah Sarawak. Would you believe that for a long time, the Chief Minister of Kashmir was called Prime Minister of Kashmir? Northern Ireland in the United Kingdom is like Sabah Sarawak, special. For a long time, the Northern Ireland Prime Minister, the Northern Ireland Chief Minister was called Prime Minister. So you can change for the sake of giving him a special position. You can change him from a Ketua Menteri. Actually, last time it was Menteri Besar, then became Ketua Menteri. Now you want to call him Perdana Menteri. But I just want to mention to you that in the 20 points, Sabah demanded that the head of the head will be Yang di Pertua Negara, and the Prime Minister will be Perdana Menteri Sabah. But both those points were ultimately rejected. It's up to you what name you want, but legally the situation is they're all Ketua Menteri or Menteri Besar, and it's a Negeri, not Negara.
Thank you, Prof. I observed some of the question posed to you. Some of it you have answered actually in your presentation. And there's a question here that said, understand until now, Federal has not given much recognition to Sabah and Sarawak. What are their actually concern for not recognizing Sabah and Sarawak? What is your take on this matter throughout your constitutional career? This is a very, I think, controversial question. I don't think that Federal has not given attention to Sabah Sarawak. That's why we are here. But I would like you to answer this question, Prof.
Yeah, actually, much of my presentation was an affirmation agreement with this view that in many areas, Sabah Sarawak's rights have suffered a retreat. And Sabah Sarawak Bumiputras have not been given adequate recognition. If I may give just one example, there is a nice tradition or convention that every time someone is appointed as Chief Justice of the country, he's made a tun. But when Tan Sri Richard Malanjan became the Chief Justice of the country, he still remained a Tan Sri. As far as I know, he's the only Chief Justice, ex-Chief Justice or Chief Justice, who is a Tan Sri. All the others are Tun. So I fully acknowledge that West Malaysia has not been fair to Sabah Sarawak in many, many areas. But I think the reason was, there were two reasons. One is because the government in KL or in Putrajaya had massive 2/3. In fact, at one time during Tun Abdullah Badawi's time, at that time he was Datuk Sri Abdullah Badawi, he had 93% seats in the Dewan Rayat. So a government that has 93% seats in the Dewan Rayat, or 2/3 repeatedly, doesn't bother too much about others. I'm afraid that was so. The steam roller majority of the Barisan Nasional made the Barisan Nasional kind of indifferent to any other agenda other than its own. But that has changed now. I think the age of 2/3 majority is gone for some time. I don't think we'll have 2/3 for a long time. We may have again, but it may take a long time. So I think Sabah Sarawak need to press on. Their demand should be based on the law rather than on emotions, because I think the federal government is under considerable political pressure to listen to these demands, and I think some things will be achieved. I myself had the privilege of being on the MA 63 committee after the Pakatan Harapan victory, but then its report was not made public. So I think we need to push on. Sabah Sarawak governments, this is the right time. This is the right time to make your point. The first step should be to find out what your rights were, which were violated, to restore them. The second effort should be, even in those areas where you do not have constitutional rights, you may wish to re-bargain, you may wish to renegotiate issues. For example, on petrol royalty. I know some of you won't like it, you'll get very angry with me, but doesn't matter. I'm not a politician. I'm not seeking anyone's vote. In the federal constitution, in 1957 and 1963, oil and oil fields were in federal hands. From day one, oils and oil fields were in federal hands. All that Sabah Sarawak were given actually were a right in Schedule 2, Item 2C, to permits and licenses for prospecting for mines, mining leases and certificates. So the permit, you can collect money from that, but the oil and the oil field is a federal matter. Well, maybe you need to renegotiate. You need to renegotiate. There's nothing impossible about renegotiating and saying, look, Sabah Sarawak contributes so much. Sabah Sarawak oil, Sabah Sarawak timber, Sabah Sarawak hydroelectric, Sabah Sarawak tourism contributes so much to the national exchequer. Therefore, you must give us some greater share of those resources which originate from Sabah Sarawak. So this will require. So basically, the point I'm making is, first of all, discover what your rights were under the law, not by way of emotion or by way of political demands. Discover your rights under the law, seek their enforcement. Secondly, in those areas where you may not have the right, please seek renegotiation of MA 63, seek amendment of the Perlembagaan Persekutuan. There's no difficulty about renegotiating. Thank you.
Thank you, Prof. There's another question. This is more or less a question of nation building, which you are also familiar with. From Encik Muhammad Yunus Zul Haizat. Dia berkata, Prof, salam Prof, may I know what is your view on implementation of negara bangsa and how stroke what to do in achieving the concept of negara bangsa?
Yeah. Actually, I am not really sure how to answer this. I certainly believe that all of us should put our nation first, but at the same time, I want to clarify, never will I concede to this point that we all have multiple identities. Besides being a Malaysian, I'm also a Muslim. I'm also a law person. I'm also a father, a husband. I'm also a member of my neighborhood, multiple identities. So I think we should allow unity in diversity. I think the model of nationhood to me should not be the model of a melting pot. In a melting pot, everything goes in and changes. Everyone becomes the same because of the melting pot. I would rather take a mosaic. I prefer the model of a mosaic than a melting pot. I think unity does not mean uniformity. It has to be a unity in diversity. So while being Malaysian, to me, there is nothing wrong in people saying, yes, I'm also X, Y, Z. For example, many of the views I adopt in my life are because of the fact that I'm a law teacher, that I'm a student of constitutional law. On issues of human rights, I'm guided by my limited knowledge of law. So I'm all for Nagara Bangsa. I'm all for the idea that nation come first. But first doesn't mean there's nothing else. From day to day, my identity changes. When I'm in my classroom, I'm a law lecturer first. Or I'm writing an article, I'm a law lecturer first. When I'm at home, I'm a father or a husband. When I'm in the neighborhood, then I think that we all live, Dr. Norizan, we all live at the center of a large number of circles of loyalty. So I want to say this to Brother Yunus. We cannot deny that there are many circles of loyalty. Do not attempt to wipe out these identities. It will not work. People are not going to forget their religion or their race or their gender or their culture. They will not forget. The important thing is to emphasize commonalities, to build bridges across the rivers. But you can't deny that the land is divided by rivers. We can build bridges, but you cannot deny that these differences exist. They exist everywhere. I remember, Dr. Norizan, many decades ago, the Pope happened to be from Poland. I forget his name. I think it was Pope Paul. The Pope was from Poland. Poland at that time was a communist country. This is before the fall of the Russian Empire, before the fall of communism. Now, when Pope decided to visit Poland, hundreds of thousands of Polish people assembled on the streets to see him. And it was amazing because Poland was a communist country. In communist countries, you don't emphasize religion. But yet, you know, people had not forgotten their Catholicism. So when their Pope arrived, they came out just to be able to see him. So what I'm saying is this: people will not forget their religion or their race or their gender or their other distinctiveness. I think that's the beauty of human civilization, that though we are all in some respects human, in some respects, at the same time in other respects we are different. And these differences should be celebrated. They should be regarded as an asset rather than as a liability. I'm all for Bangsa Nagara. I'm all for it. And I personally don't like the idea of all the Borang saying, what is your Bangsa, and so on. I don't like that at all. Even want to ask for a driving license, you have to mention your Bangsa, which I think is so totally irrelevant. Nevertheless, I think we should recognize that unity does not mean uniformity. Thank you.
Thank you, Prof. That is a very interesting point you bring. Unity is important. I would like to ask a question. How different we are from Indonesia, which practice Pancasila?
Yeah, actually, Indonesia clearly, though so greatly linked with Malaysia in terms of race and religion, Indonesia has different fundamentals. They put their Pancasila as something which is the guiding light of their nation. We don't do that to our Rukun Nagara, though we do have a beautiful Rukun Nagara, but actually we use it more as symbolism. Once a year or twice a year, people will talk about it. Otherwise, we don't live by it. I think Indonesia, except in areas like, well, in some areas where there is a very, very distinct emphasis on a particular religion or particular way of life, I think Indonesia has done a much better job than Malaysia in terms of multiculturalism. I'm a great admirer of multiculturalism. As I said, unity should not mean uniformity. To me, Dr. Norizan, being able to live together with others in peace and harmony is the mark of civilization. A civilization should not be known simply by the wealth it generates and the rockets it creates and the moons on which it lands and the territories it conquers. No, I think the mark of a true civilization is the ability to live together in peace and harmony with fellow human beings. And I think in this respect, I admire Sabah Sarawak, who are on a higher scale of civilization than some of us in this part of Malaysia, who actually, and I admire Indonesia. In Indonesia, there is much greater inclusiveness. You see the president of Indonesia on special functions, he will not only say Assalamu alaikum, he will also actually welcome the other communities. I like that very much. I like that very much. I think he should acknowledge that he's the president, not only of one race or one religion, he's the president of all. Many of our leaders are like that. Many are like that, but sadly in the last 3-4 decades, we have become more insular. We have become less inclusive. We are talking about a sort of a situation where we forget that we are actually a nation with a lot of diversity, and that has been our strength.
Datuk Norizan, can I ask a question?
Miss Susanna, from where are you, madam?
I'm here in KK.
Okay.
I'm Datuk Suja Surya.
All right.
I would like to ask Professor, I would like to say thank you to Professor for the excellent forum with a comprehensive presentation and fantastic questions and answers. My question is, can we get a written copy of the presentation with all the questions and answers, and how do we get it? Thank you, Professor. Excellent.
Susanna, if you can give me your email, I will promise to send you a copy of my presentation. No problem. But the Q&A, that's beyond me. I was not recording. I'm sorry. This is recorded actually by the Kementerian. So on that, I have to seek Dr. Norizan's help. But for my presentation, I'll be very happy to send it to you. No problem at all.
Dr. Susanna, I'll be happy to assist you. You can email to me, norizan@jpm.com. www.gov.my. We, for others who are listening to this webinar, I also recorded it. Yeah, if you want a copy, I will be happy to forward it to you.
Thank you so much.
Yeah.
Dr.
Thank you,
Noridan,
Datuk.
can I have one more question, Nicholas? Yeah.
Yes, sir.
Yeah, thank you very much. Professor Dato, I'm very
Datuk.
touched by your statement or your word of diversity in unity in diversity. Now, my concern is Malaysia government is focused so much on the unity, you know, until there is if I'm not mistaken, there's one ministry called it
Yes.
Perpaduan, what do you call it, the national unity or Perpaduan Negara. So there was so much talk about it. There's so much seminar I've attended many times. Why is it not possible to get unity as expected in the country? Why some people are in the country cannot achieve that unity? To me, this is my view. Why is it not possible? Because you know what happened in the country. Even today, people talk about demi agama, demi bangsa. So this can be very sensitive to certain races. So the focus here is, it seemed to me that certain race is more important than the other races. Now that is very sensitive, but I don't mind to say that, you know, because it is so much deep concern in my heart. As long as there is misunderstanding on many things in the country, like for instance, there's so much corruption, so much abuse of power, so much discrimination, oppression. Like just now I talked about land. Our land have been taken away by using policies. So all these matters, of course, make people very unhappy. When people are not very happy, how to make how to achieve unity? Of course, we want unity. Unity is the best thing for the country where everybody respect one another. But here in Malaysia, we talk so much about unity. There are so many laws, there's so many policies, but a lot of the policies seem to me are biased, you know. So what is your views of the current situation? Why it is not possible to achieve that unity that we want it to be? But, you know, I mean, having all these obstacles and barriers, how do you perceive the future of this country, Datuk?
Yeah. Datuk, thank you so much for your question. May I just say this, that compared to many other Asian and African societies, Malaysia has done fairly well in terms of preventing racial, religious, or regional violence. I know many things are not satisfactory and we need to improve, but nevertheless, as a matter of broader perspective, if you compare Malaysia to Sri Lanka or to India or to Pakistan or to Iraq, Lebanon, so on and so forth, many Latin American countries, we have by far and large done fairly well. I just want to share this with Dato. At one time, an American embassy officer once asked me, he says, how come Malaysians don't kill each other? He asked me this question. I said, well, I can't answer that clearly, but it seems to me we all have a stake in the country. We feel there is something in it for us. We don't want the country to burn because we want the country to grow because we know we will grow with it. And I know there have been incidents like 1969 and a few others, but by far and large, this country has done fairly well. So I want to put that as an international or a regional perspective. That at one time, Malaysia scored fairly well on a World Peace Index. We scored fairly well. However, I fully acknowledge with you, there are a lot of areas where we have regressed. We have moved backwards. we had a winning combination. We are giving up our winning combination and we are adopting things that actually are tested and tried and failed elsewhere. Other countries try to snatch victory from the jaws of defeat. They try their best to become victorious in tough situations. We are trying to snatch defeat from the jaws of victory. All along, actually, we were victorious in having a nation where there was prosperity, where there was racial harmony. Now we are trying to change things, and I think that's not wise at all, especially in our relation with Sabah Sarawak. Our conduct has not been quite wise. I take note of what happened in Bangladesh. Datuk, East Pakistan, West Pakistan were one country, but separated by 1,000 miles of Indian territory. And then because West Pakistan refused to work with East Pakistan in terms of equal status, in terms of fairness and justice, ultimately there was a freedom movement by the Awami League of Sheikh Mujibur Rahman, and East Pakistan went on to become a separate nation called Bangladesh. Just last year, I think last year or 2 years ago, Sudan split into north, south, so on and so forth. So I think we were doing well, but we were regressing. But it's never too late. Never too late to build bridges of friendship. What needs to be done? That there'll always be extremists in every land. There will always be people who will hide in the gutters and will summon us to join them there. There will always be people who will rely on race. Look at the USA during the time of Trump. He was basically using race to divide the people, race and religion to divide the people. There'll always be people like that. In India, the present Prime Minister. There'll always be leaders like that. But on the other hand, there are equally other leaders who actually caution moderation. May I just give a few examples? 2 years ago or 3 years ago, there was some guy in Johor who said, "Laundromat untuk orang Islam sahaja." And I think the Sultan of Johor correctly reprimanded him and said, "You don't do that." So Perlis also took a stand on that. Negeri Sembilan, Perak, they take a stand on many of these issues. I think our sultans can play a role. Our leaders, political leaders, must not just keep quiet when people talk about racial supremacy or people indulge in racially hatred speech. They should condemn it. They should come out and speak and say, that's not the way to behave. I remember the statement by Jesse Jackson, who said, leaders of substance do not follow opinion polls. They mold opinion not with guns or dollars or position, but with the power of their soul. So if someone in parliament gives a racist speech or a sexist speech, I think the Prime Minister should say, you don't do that in this country. You're wrong. You should not do that. The Speaker must cite that fellow for contempt of the House. So the sultans can play a role. Political leaders should play a role. Religious leaders should play a role. Religious leaders. So if someone says during this COVID, someone says that this aid is available only for groups or only for people of this particular religion, I think religious leaders of that community should stand up and be counted and say, this is wrong. This is not according to our religion. Religious leaders should stand up and say, this should not be done. And of course, you and I, we are nothing. We are ordinary people. But nevertheless, let us not underestimate the power of one man or one woman. Let us not underestimate. I've always said this, let me say it again, sometimes in the desert, a sand dune grows around a single blade of grass. In other words, one man with moral conviction, with ideals, with a passion, with courage can make a difference. In fact, throughout history, it is lone rangers who have made a difference. I think all of us, when we see racism or religious bigotry or sexist behavior or behavior which denigrates other regions, I think we should stand up and criticize it. We should be like the person who throws a small stone on the surface of a placid lake. The ripples will move farther and farther and farther. I think we all have a role to play. So Dato, I totally agree with you that racism, religious bigotry, gender bias, regional bias, regional discrimination is becoming mainstream. We need to nip this in the bud. We had a winning formula for living together. We have done well. Up to now, we have done fairly well. We need to improve. We all have a role to play. Thank you.
Thank you, Prof. I share your thoughts. I believe that we have issues and challenges, but indeed we are always stay as a nation. In fact, I would like to share with Datuk Nicholas, Malaysia is one of the 20th most peaceful country in the world.
Yes, yes.
According to the Global Peace Index 2020. Yes. Yeah. Let's us maintain that or even make it better, Prof. Of course, yes, there are issues and challenges to that. Let's make unity our culture. Yeah. I will allow one more last question, Prof, if you're okay.
Okay.
I have some burning question from this young guy named Irwan Idris. Let me it short and sweet, Irwan, to ask the professor.
Hello, Professor. Selamat pagi.
Hi, Irwan.
Hi. Actually, I'm very new with this MA63 and the IGC and Sabah Sarawak talk. So today, happened to join your Zoom. Yesterday, somebody sent me the link. So I've been listening to you and I've been looking at the document. So I have a confusion here about the Constitution. Actually, the question is very simple. What is the status of 20 points and Malaysia agreement in our Constitution? That is the question.
Yeah, well, the answer is quite simple, Irwan. 20 points of Sabah, 18 points of Sarawak, the IGC agreement, the Cobalt Commission. These are what could be called pre-constitutional documents. Foundational, constitutional, pre-constitutional documents. They are having tremendous moral force. Moral force. They represent a gentleman's agreement. They were the foundation on which a new country was built. However, strictly speaking, they are not law. To be law, they must go through either an act of parliament or an amendment to the Perlembagaan Persekutuan. So, for example, I have here a copy of the 20 points of Sabah. I'm just mentioning this. Point number 13, the Prime Minister should be elected by unofficial members of the Legislative Council. Prime Minister of Sabah. So actually in the 20 points, the proposal was that the Sabah political head should be called Prime Minister. Obviously, this had no effect. And then point 18, Yang di Pertuan Negara. It was not Yang di-Pertua Negeri, Yang di-Pertua Negara. So these 20 points, 18 points, they are not law by themselves. They are actually, however, as I said, foundational documents. And in many countries of the world, like in the UK, I'm sure you have heard of the Bill of Rights. It is a bill, not an act, because it was never passed by Parliament. Nevertheless, everyone swears by it. The Magna Carta, oh, they swear by the Magna Carta. It is a foundational document. Magna Carta is to England what the 10 Commandments would be to the to the Christian faith. But these are not law, strictly speaking. But they have a moral force.
Thank you, Prof.
Thank you.
Thank you, Prof.
Thank you, Prof. Thank you, everybody. Thank you, Prof. Today, presentation, I really enjoy. I'm sure everybody has enjoyed the presentation too. And as we are here to share our knowledge and our experience, and we hope for a better Malaysia. We hope to build a better nation. As I mentioned earlier, we are one of the most peaceful country in the world, and we want to make it better. Yeah?
Yes.
This is, I'm sure everybody have a very hard times, but challenging time, but we can overcome it. Yeah. Kita nak ambil gambar